This week, the National Association for Gun Rights, in conjunction with our legal arm, filed 5 new federal lawsuits against magazine and assault weapons bans in 4 different federal circuits: Connecticut, Massachusetts, Illinois, and Hawaii. The lawsuits are springboarding off the initial success we've been having with our 5 lawsuits in the state of Colorado, where Democrat-appointed federal judges have approved temporary restraining orders against the municipalities who are trying to enact them. The relatively short complaints, most around 12 pages, use this summer's Supreme Court decision to eviscerate local and state limits on magazine capacity and banning virtually all commonly owned semi-automatic firearms. Our lawsuits, right now it's a total of 10, place the burden of proof on the defendant, the cities, counties, and states who seek to enforce these gun controls, to prove their ordinances fit within the new Supreme Court directives on Second Amendment cases. The Supreme Court's Bruen decision gave us a 4-ton wrecking ball to dismantle gun control laws nationwide, and we're going to wipe out every unconstitutional law that stands in the way of citizens' Second Amendment rights. For too long, our Second Amendment rights have been treated like red-headed stepchild of the Bill of Rights, purposely relegated by the court system to a second or even third-tier position to other specifically delineated civil rights. While many courts have ruled that the First Amendment is virtually without limits, and rightfully so, they have made gun owners sit in the back of the proverbial bus. Now, using a 2-step approach, most courts have largely ignored the text of the Second Amendment, instead opting to balance those civil rights with siren cries from the hoplophobes and gun ban crowd. All of that changed with Justice Clarence Thomas's majority opinion on the New York State Rifle and Pistol Association v. Bruen case. He called the 2-step approach one step too many. Now, Clarence Thomas wrote that, quotes, "The government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms." Now, what he's really saying is that the Heller and McDonald decisions, and now Bruen, do not permit a court to engage in a balancing test to determine whether the harm of burdening the Second Amendment right is justified by the benefit the state seeks to accomplish by means of the regulation. Instead, the state has to prove that its regulation is consistent with the nation's historical tradition of regulation of firearms. Now, that's pretty clear. There's really no ambiguity here. Government must prove its regulation of a citizen's firearms is consistent with the text, history, and tradition of the Second Amendment. Now, you're going to hear that a lot over the next few decades. Text, history, and tradition. Frankly, it should be a mantra of ours. Now, is that going to be enough to defeat the large capacity magazine bans and assault weapons bans? The Obama and Biden-appointed judges who ruled in favor of our temporary restraining orders to stop enforcement must think so. Both granted the restraining orders because of the plaintiff's likelihood of success. Now, notice the 2 descriptors I used, and that I used them intentionally. Our filings all challenge those terms, large capacity and assault weapons, because they're both politically charged misnomers created by those who wish to ban them. A 30-round magazine is the standard capacity magazine when purchasing any variant of the most popular rifle in America, the semi-automatic AR-15, and even for an AK-47. In fact, unless you live in a state where the government entity restricts magazine capacity, you would be unable to find an AR-15 for sale from a manufacturer, a wholesaler, or even your local gun shop that did not include at least one 30-round magazine like this one. The same goes true for the most popular handgun sold in America, the Glock 19, which is sold only with a 15-round magazine, their standard capacity. A 30-round magazine, when buying an AR-15, is the standard capacity, not the exception. Also note, I mentioned that the AR-15 is the most popular rifle sold in America today. Its sales far outpace any other rifle. These are very common firearms and magazines, which states and municipalities are banning, and which the U.S. Supreme Court now says must be evaluated in a much different light. If states think they can keep ignoring the Heller, McDonald, and now the Bruen decisions, which affirm our constitutional right to own and carry all kinds of firearms, we have one message for you: see you in court. Now, why do we file lawsuits in those venues and not in others? We found regulations that have not yet been challenged in court. In many other areas, like New Jersey, Delaware, and California, there are already active challenges. Now, to be honest, nothing makes me happier than dropping a scathing lawsuit right in an authoritarian laps of states and cities hell-bent on eviscerating the gun rights of their law-abiding citizens. Millions of law-abiding Americans in Massachusetts, Connecticut, Illinois, Hawaii, and Colorado have been denied their right to keep and bear arms for decades, and our lawsuits will free them from the tyranny of unconstitutional gun controls. Now you can click this link to become an honorary co-plaintiff, or you can read about those complaints in the description below.